Good evening, everybody. Afternoon, everybody. Yes. Okay. Thanks for coming in the eve of the grand final public holiday. We've got a public holiday now for footy as well as horse racing. So I'm very pleased today to welcome Professor Graham All from the University of Queensland. He is an expert in the area of law and politics, and he's been very prolific. He's got a lot of things coming out soon. The Law of Politics, second edition in Federation Press next year. He's had a recent book on election as rituals, Routledge, out this year there'll be the Cambridge Handbook of Deliberative Democracy. So you can look forward to many publications by Graham. So today he'll be talking about the recent circus that we've seen in the MP disqualifications and Section 44 of the Constitution. And this event is co-sponsored by the Graduate School of Business and Law at RMIT and also the Electoral Regulation Research Network. So thanks, Graham.
Thank you, Fui. And I want to thank RMIT and Professor Greg Taylor, who lined this up a year ago, although Greg's in Germany, I think.
He's having fun.
And thank you to be host, but also thanks to Ju Chong Tam of Melbourne University and the Electoral Regulation Research Network for co-sponsoring and publicising this. I won't stand up. I've been up since 5 a.m, so I might fall down. But it's great to be in Melbourne, which is the coolest city in Australia, in both senses of the word, because it's 37 degrees in Brisbane. So better mild. Everyone complains about the weather here, but truly, I'm a climate change refugee today. Now, the topic is the farce, and that's what it is. It's not a constitutional crisis around Section 44. It's certainly a long and outmoded provision, as I will argue, and I don't think any branch of government, the courts, members of Parliament, and even the executive, I don't think they've handled Section 44 rationally or consistently or very well over the years. It's a bit like a burst appendix, which is infecting body politic. Now, does anyone know who the handsome gentleman on the steed is? Political scientist here?
Where is it from?
That's a British museum, but he's not British. He's Roman. It's Caligula. He apparently was a very handsome young emperor, and his horse is Incitatus. So maybe you know that this is a reference to the famous fable of the wacky young emperor threatening to appoint his favourite horse as a Roman consul, a post that only a senator could hold. So the horse would have to be appointed to be a senator. Now, I could have shown an image of Cacareco. Apparently there's a white rhinoceros in Sao Paulo in the 1950s who, in an election for 40-odd members of the city council, and there were 540 candidates, the ballot was topped by a rhinoceros that got well over 100,000 votes in a kind of write-in. Americans would call it a write-in candidate. He wasn't actually nominated. And overwhelmingly, Cacareco was, in theory, the most popular. So the metaphor for qualifications is there. Obviously, there have to be some qualifications. But in neither case could the horse or the rhinoceros qualify for office. There was a simple legal rule that to nominate you had to be a human and an elector. And I want to argue that that's pretty much good enough for me, I think. If you're an elector, why shouldn't you be allowed to choose any other elector? I'm talking here about elections, though. There may be different things to apply if someone else ends up with a significant conflict of interest they can't get rid of whilst they're an MP. That is a distinguishable matter. Now, Australia's MPs may occasionally be asses, but they're not horses. They are fellow adult citizens. They're electors like us. The MPs who have been sent to the High Court in the past year or so, they've all been elected in democratic contests, most of them on the basis of their party affiliations, I should add. None of them were foisted on us by the fiat of a wacky emperor. And I think to a Democrat this should make all the difference. So Section 44, and I've been arguing this since at least 2010, is not a particularly democratic provision, although it's one that we are currently stuck with. So it is the current law, and laws have consequences and sanctions, albeit not always simple ones. So a lot of my talk will be about some of the funny procedural and other consequences of this provision. And there are people, I'm not one of them, that want to take a more fundamentalist line to Section 44. The Constitution must be enforced strictly, even if the Constitution is an ass. So a good colleague of many of ours, Michael Maley, formerly of the AEC, says, borrowing from the French Revolution, pour l'encourager les autres, we need to enforce it strictly to encourage the others. The system must guillotine a few heads occasionally to encourage better compliance by politicians in the future. But between these two different positions, one is that Section 44 is an ass and needs to be either ignored or washed away as far as possible, or it needs to be rigorously enforced. The reality in the middle is not so easy. It is conceptually flawed. In some respects, Section 44 is too fuzzy to be enforced fairly, and if so, we need to consider reform options. The second visual to kick off the talk is this. You know the old gag of the so-called Mexican firing squad. Well, here it's being used as a joke about gridlock in the US Congress. But I think it's also a perfect metaphor for what's happened this year in the Australian Parliament's reaction to the unfolding questions about MP qualifications. Everyone is in the same boat, in theory. But instead of a rational or fair response, it's been a case of partisans turning on each other. Initially, the government and Labor mocking minor parties, then Labor mocking the National Party, and so on. I think the bloke holding the sword here could represent the media, who have also stoked the farce with a lot of gotcha journalism. And I've fielded calls nearly at midnight from certain journalists, wanting me to give them legal advice for their morning edition about the next MP. These are MPs who haven't been referred, who shouldn't be referred. But for the media, a lot of it's been gotcha stuff, and I really, really do not want to be around for the next election, because I think we know what's going to happen. We know that anyone whose name isn't clearly maybe Indigenous or fourth generation white Australian, journalists are going to be, and their rivals, will be saying, come on, show us your grandparents' records, prove a negative, which of course any scientist will say you cannot prove a negative, not definitively, prove that you are not a dual citizen. And this is going to dominate, unfortunately, some of the campaign at a time when we need to be thinking about much more important issues. So a rational organisation, not a Mexican firing squad, but a rational parliament, one that was less concerned about internal competition, faced with a systemic problem about issues of paperwork involving its members or staff, would have done this. It would have had an audit, it would have had an amnesty, and it wouldn't have reflexively referred cases to the High Court. Remember, at worst, some MPs have been neglectful, not fraudulent. Senator Roberts, for all his possible foolishness, Justice Patrick Keane in the High Court the other day said that he accepted the sincerity of the evidence that Senator Roberts had always assumed that he was Australian because that was his family folklore, didn't realise that he'd had a citizenship that he hadn't properly renounced. But also, in most cases, there are reasonable explanations for the ignorance or confusion. And also remember this, how can someone actually have a conflict of interest if they were unaware of it? In Section 44, we are told the rationale behind it is to avoid conflicts of interest and duty. Section 44, as we'll see in a moment, erects a thicket of disqualifications and has some very fuzzy aspects, not just in relation to dual citizenship. However, Parliament blindly went down the path of referring MPs one by one. And in fact, it went down this path late last year, when, in good faith, but thinking, it's just a couple of minor party figures, Senator Brandis referred Senator Day and Cullerton. Remember, one of them had an office lease for which the Finance Department had actually paid no money, and one had a minor conviction that had been set aside. They were both referred to the High Court in different decisions, relying on different judicial interpretive practices, as we'll see, unseated both of those MPs. But the precedent was clearly set that in any case where we think there's a concern, we will refer the matter to the High Court. And the High Court will backdate the election result, which is a thing that really concerns me. This idea that you can backdate election results up to 6 years after the event seems to me highly problematic. particularly when, say as in the case of Mr Joyce or Senator Waters, the unknown dual citizenship was immediately renounced anyway. In a rational parliament, you would have just said, amnesty, time to renounce, get rid of the conflict, and we'll move on. But this hasn't been a rational process. And we lawyers like to think that things can be done rationally. All right, so an overview of the guts of the talk, and the handout you've got is, if time permits, there's 4 things to look at. One is the question of form. Where do we get this law from? Where does it sit? One is substance, provisions and case law. One is process, and the final one, if we have time, is reform. So, form. Basic constitutional law. The Australian Constitution, as you probably know, but as at least half Australians don't know, is a single written document. It is rigid. It needs a referendum to formally change the letter of it. High Court rulings rule. So when the High Court in the 80s and early 90s made some decisions that were procedurally too strict, until the High Court undoes those decisions, there's nothing the Parliament can do. So we're often stuck with case law in this area, the area of elections, that is often, put it mildly, the High Court are not experts in this area of law. They're great lawyers, but they haven't read as many books as me. But they get cases thrown on them very quickly. They're told they have to resolve the cases very quickly. Often there's litigants in person or minor party figures and independents who aren't properly representative, so you're not necessarily getting the best jurisprudential sausage out of this machine. On the other hand, look at state constitutions, if you can find them. They're not a single document, they're multiple evolving acts of Parliament, so they're flexible. The state Parliament can amend its state constitution quite simply by majority, except in rare cases where an earlier Parliament has locked in some procedural matter about the constitution of the Parliament. So that's pretty rare. So the states, because they were colonies, children of the UK, inherited this idea from the UK that you have constitutional flexibility. But the Commonwealth, because it's a federal system, and you can't have a federal nation without a written, rigid constitution dividing powers up. They also threw in a few odd appendages like Section 44. And Section 44 was one of those things that maybe it was a good idea at the time, but 100 years on, it's not. So these are barriers in Section 44 to either being elected or to continue to sit in Parliament. And I want to focus on the idea of democratic elections being constrained or narrowed. So obviously, a hugely charismatic figure like Clive Palmer shouldn't be able to be elected to both houses. Section 43. Then Section 44. This is the one we're talking about a lot in the last few months. It's called the dual citizenship power, but actually it's a bit broader than that. For instance, I had to advise a gentleman called Julian Reforms, who's holed up in, as you know, in the Ecuadorian embassy. First of all, about whether he could get on the electoral roll, which he did. Then about whether he could stand for the Senate in Victoria, which he did. But if you think about it, if there was anyone who had a potential conflict of interest and duty, someone who has sought political asylum in a foreign embassy would be that. But on a strict reading of Section 44(1), he's not a dual citizen, he's not entitled to the majority of the privileges of a citizen, such as to vote in Ecuadorian elections, but no one in the world could be more at risk of influence from another country than he was at the time, but it was fine for him to stand for the Senate. Luckily or otherwise, people in Victoria only gave him 1% of the vote, but minor party figures have been elected with less than that. But in other cases, Senator Wood, Nuclear Sum Party, British dual citizenship, lost his seat, and this was perhaps the originary problem in this case because it was a parliamentary reference. He had been petitioned by Fred Niles' wife. So an election petition is something any elector can bring within 40 days of election, but she didn't get the petition right, didn't petition in time. He would have thought, okay, that's it. The election is over. The time limit for petitions is over. We get on with our life. No, the Senate in 1988 decided to refer the matter. Hey, it's just the NDP. He was kicked out, and the High Court interpreted the law to say they had power to backdate and undo the election. and in effect contradict the rule that election petitions and disputes have to be resolved within a short period after an election, which is a problem in itself. A case involving Senator Hill, One Nation MP, which curiously reflects what's happening to Senator Roberts, but she knew about her potential dual citizenship because she had applied for a passport and travelled on a British passport. Okay, so the High Court's got 7 senators. It's a pretty rare case where you've got such a gradation of fact scenarios before you, and that's going to be an interesting part of litigation. There's a case that the section that developed Mr. Cullerton. He was the interesting One Nation turned independent guy from West Australia who had been charged with larceny in New South Wales because he'd held on to a key for a pickup truck or a tow truck for half a day. He was convicted in absentia. He wasn't able to attend the trial in New South Wales, but then he appealed and was unconvicted. The High Court ruled earlier this year that because at the time when he nominated he was subject to the conviction, they took a very strict literalist hardline rule. It didn't matter that a court later said that the conviction was completely null because he hadn't been given due process. Okay, again, just a minor party figure, bad luck. Undischarged bankrupts. So the guy who may replace Senator Roberts, the third person on the ticket for the One Nation in Queensland, is going through bankruptcy proceedings. If he's made bankrupt before the High Court says that he is the new senator, maybe he will then fall into the void. We'll mention that later. Besides dual citizenships, the other one that affects hundreds of thousands of Australians is this one. What is an office of profit under the Crown? It's archaic language. I'm not sure if academics are caught by that. A lot of people who work in local government. We know that public servants are caught, but we don't know about the rest of the onion. We may be sitting in Mr. Phil Cleary's old constituency. I'm not sure. The seat of Wills, did it take in? Not this far. Finally, there's the one that caught Senator Day, which is a bit like office of profit, but it relates to contracts. If you have a pecuniary interest in an agreement with the Commonwealth Public Service, except as a shareholder in a modestly sizable corporation. Senator Day thought he was okay because he'd got good legal advice on the law at the time, but the High Court changed its previous ruling and purposefully expanded the ruling about this area of the law to capture Senator Day. So he would have felt, a bit ripped off, paid for all that legal advice. The law changes through High Court interpretation after the event, and he was knocked out. But in that case, instead of using literal interpretation, the court used a broad purposive interpretation and expanded the net of who is disqualified. In the cases before the High Court currently, the Attorney General wants to argue for not a hard literal interpretation, not an expansive purposive interpretation, but wants to argue for a narrow purposive interpretation. So the High Court in 1 year might go through 3 different interpretive methods in the one section. Admittedly different parts of the section, but in theory Section 44 should have some holistic rationale. There's also a matter where the ALP is suing the Commonwealth member for Lyne, a National Party MP. This is the case involving a guy who owns a shop, leased the shop, I think, and the shop was then subleased to Australia Post. Now, it seems to me he's clearly okay. Australia Post is not the core public service. The chances of him leasing or subleasing a shop to the Australia Post affecting his ability to be an MP is incredibly tenuous. But for whatever political reasons, the Labor Party is suing him, and they're suing him, as we'll see, using a procedure that's never before been used, as far as we know, in Australia in the last 115 years. So it's not a reference by Parliament, it's the ALP saying, we will sue as common informers. Explain that in a moment. All right, that's the form of the law, Section 44. Substance, why do we have it? Well, in theory, you look at Section 44 and there are some incapacities there, maybe criminal conviction. Mind you, you can remain as an MP with a more serious criminal conviction than what you'd be disqualified to stand as an MP, which is a bit of a constitutional curiosity. But most of Section 44 deals with alleged conflicts of interest and duty. And this is where the High Court might rule purposively and narrowly and follow the Attorney General's argument that, well, how can you have a conflict of interest if you didn't know that you had a dual citizenship and you reasonably didn't know you had a dual citizenship? That's the alleged rationale. My rationale is that in a more holistic democracy, we wouldn't prevent electors, adult citizens, choosing any other elector to represent them. Why would we narrow the pool of people in this day and age where the media and social media and rivalrous campaigns are quite robust? Why would we say there are people who are off limits? Unless there was very strong, clear grounds that they have some serious conflict of interest that cannot be resolved. As we'll see, the states with their flexible constitutions have got around the Section 44 problems by saying anything that is a serious conflict of interest will only kick in if it kicks in whilst you're an MP. All right, so there is a workaround and the states have found it, but they didn't need a referendum to do that. All right, I said I was going to threaten you with some process issues, and this really is it's a law. I mean, this is a big political palaver, but we're really talking about the process of the law here. So the process in theory is, well, before an election, the parties have an interest in informing their candidates of the law, Section 44, and of vetting candidates. All right, but that's easier if you're a major party. It takes significant resources. There's not a lot of suburban lawyers you can go to and get the vibe advice about Section 44 from. I've given lots of free advice over the years to independents and minor party figures, but the major parties have got their collections of barristers' advice and High Court opinions. They have the resources to gear up for pre-selections well in advance, and they have one significant advantage in Commonwealth elections. At least one of the major parties has a strong sense of when the election's going to be called. Because remember, you can have a snap election, and last year, although there was a 2-month campaign, it was a snap election. Whereas with minor parties and independents, well, you kind of expect them not only to know there is this thing called Section 44 tucked away in the Constitution, know it well enough in advance that you can spend months getting advice, sometimes from expense from overseas lawyers, about whether, thanks to your parents or grandparents or a marriage, you were a dual citizen, or what the heck is an Office of Profit under the Crown, and how do I leave my Office of Profit under the Crown and risk my family's economic future, given that I am probably not likely to win this election. I'm just standing to give broader choice. People sometimes say to me, why can't the Electoral Commission do this? You know, we expect the Electoral Commission to be, it's independent, it's very thorough, it's one of the best in the world when it comes to the logistics of elections. Why the heck can't they just go around and check with the United Nations who is a citizen of which country? Well, countries don't have and publish registers of who is a citizen. Countries do not know who are citizens of themselves until they hear from you that you've got a grandparent and you want to register as a citizen. So we can't do that one. Even if we could, it would put the AEC in a difficult position. Because imagine this. Election is called. We've got to get nominations finalised within 10 days of the closing of the writs. The AEC starts saying to some people, sorry, you can't nominate, we think you're a dual citizen. Candidate goes away. Disgruntled potential candidate goes away and says, these guys are being partisans. I'm going to litigate. What a mess. Also, there's this funny thing that I think Tony Windsor is going to argue. This is the idea that, well, if facts are known in the electorate, and those facts, if you're a good lawyer, would point to that person being disqualified, then under 17th century British law, electors have thrown their votes away. I think that's what Tony Windsor is going to argue, because he wants the High Court to say, I should have been elected. Not only that Joyce wasn't qualified due to some unknown New Zealand citizenship, but that the consequence of that, if the electors had reason to know that Joyce had a New Zealand father, and it probably was on the public record, that, well, the election hasn't completely miscarried, we just ignore the votes for Joyce. And this is good 17th, 18th, 19th, 20th century British law. We don't know if it's good Australian law. The High Court has said in the past maybe it will apply at least in two-horse races. I'm pretty sure the High Court will say no, it doesn't apply, because what could be more undemocratic than giving an election to a rival, even in a situation where someone knew they were disqualified, because we have a party-based system. It's not a 17th century system where people used to literally meet in public, argue about who they should vote for on the hustings, and then have the vote. But that's another little curiosity that will be discussed in coming weeks. All right, how does one of these matters get before a court? Well, if you or I, after an election, wants to dispute an election, we have to file a petition in the Court of Disputed Returns, and we have to show that there were breaches of the law that affected the result. Normally, that's incredibly difficult. You have to show there's fraud or official error, and that was a close margin. So lots of bad things go on in elections, but they never end up in the courts because the result wasn't close. The exception to that is where you have a disqualified winner. Because, yes, if the winner was not qualified to be elected, therefore the result has miscarried. The outcome was affected. There are also obscure cases from Canadian Indigenous communities, obscure cases from West Australian local elections, where I advised Noel Crichton Brown once for free, just because it was an interesting question, and he went along and argued for his mates and said, look, if there's a disqualified loser and the result is close, and we have first past the post voting, maybe that upsets the election. How do we know how people would have made a different choice when they had only one choice, first past the post voting? So these disqualifications also have fuzzy consequences, at least in certain voting systems, maybe not in the Commonwealth system. But for you or I, as electors, to challenge an election, we've got 40 days. 40 days from the result to petition. So you really have to have all the facts together. You've got to be quick, you've got to have a good lawyer, and then the court has to resolve it quickly. That is one of the most fundamental laws in electoral democracy round the common law world. This is an incredibly strict time limit. That's for the purity of elections. We don't expect elections to be pure. We'd say if the election was close and there's clear evidence and you get into court quickly, maybe the courts will have a role to play. But for some reason, when it comes to disqualification issues, there are three ways in which an MP whose qualifications either to be elected or to continue to sit a question during the life of the Parliament. In other words, they've been elected, maybe a year later, a year and a half in Mr. Joyce's case, someone says, hey, I got some advice, from a lawyer in New Zealand, or I got someone to ask a question in the New Zealand Parliament, and maybe you're a New Zealand citizen, and maybe you were at the time you're elected. Well, there's three ways in which that can end up in court. Traditionally, each House of Parliament has power to rule on MPs' qualifications. So in theory, they could have just said, our advice, Solicitor General, is that Mr. Joyce is okay because no constructive knowledge, no reasonable chance to take steps. They could have done that, but it would have looked a bit dodgy. It would have looked dodgy if the government had used its numbers in the House to protect one of their own. But they have used their numbers a couple of times before to protect one of their own on good legal advice. The case of Mr. Warren Ench, who had a concrete supply through his family company to the Commonwealth, and in a case of Mr. Michael Bohm in the past. All right, so that's this very old thing that Parliament can rule on its own internal affairs. But because Parliament can rule on its own internal affairs, Parliament could also refer the matter to the courts, say we will defer to the courts, and that's what it's been doing for understandable reasons. But there's a third thing buried in the Constitution where a busybody can claim I'm a common informer and I can sue an MP and try and get $200 penalty for an MP who sat while disqualified. And that's what the ALP are doing with the guy from Port Macquarie. Okay? It's complex. Sorry?
Isn't it per day?
No, there's an act that says it's only $200 for the past year if you sat in the past year, and $200 per day after the writ is issued. So it's meant to provide a disincentive for an MP to keep sitting and not do the right thing and renounce or get rid of the conflict of interest. It's a positive provision.
The provision in the Constitution is modified.
It's been modified, and the Constitution allows it to be modified by Parliament. It is specifically designed to be a positive provision, to be a disincentive for an MP to ensure they do the right thing and get rid of the conflict of interest. So it's meant to be forward-thinking. All right. So we've got these multiple ways in which things can be court, and one day we're going to get a bit of a constitutional problem if the parliamentary majority says we think this MP is okay, and if a common informer goes to court. We don't know what will happen then, but I suspect the court will say, well, we're properly seized of the matter. Parliament, we don't care what you've said, we have to consider it anew. But that almost sounds like a 17th century problem where you have a conflict between the Parliament and the judiciary or the Crown. All right. You may know that earlier this year, kicking off this round of dual citizenship problems, it was first Senator Ludlam, who clearly wanted to get out of Parliament. Instead of using the "my family" excuse, he found out he was a New Zealand citizen. He didn't realise that. He'd been a bit neglectful, but he seemed to be happy to say, well, I resign. A week later, Senator Waters, who wanted to keep her seat, this is her life, she found out that she was a Canadian citizen. Born there, but citizen by descent because her parents were Australian. Her family had always misunderstood the nature of Canadian law, which changed around the time she was born. But the two Green senators did the same thing. They said, we've got advice that we are formally unqualified. We will resign. But you can't unelect yourself. Sure, you can resign from Parliament, but you can't declare yourself not properly elected. That's something only a court can do. I mean, the court has to decide that New Zealand is a foreign power, for a start. I did give a public talk to the Greens a month or two ago, and at that stage they hadn't got legal representation. And Senator Waters, who's a good environmental lawyer and a former student of mine, she was going to be sitting up the back of the courtroom, taking notes. Time of her life when she's going through one of the worst patches of her life. My advice to them was, get a lawyer, and they have lawyered up. But I was concerned also because Parliament refers these matters to the court, the Solicitor General comes on and argues what the line the government wants to be argued. You need to have a proper opponent. You can't just have matters referred to the High Court and the High Court not hear multiple arguments, which is one of the process problems with this parliamentary referencing. All right. These two Green senators have resigned. So regardless of what the High Court says about whether they were validly elected or qualified or not, they have fallen on their sword. Their seats are waiting to be filled, but they have to be filled by the state parliaments, because that's section 15 of the Constitution. So the Greens will have lined up, if they're not declared to be electorally disqualified, they will have to line up the person they want to renominate, which in the Queensland branch of the Greens may or may not be Senator Waters. Okay, and these provisions, were most famously used back in Gough Whitlam's days. But assuming the court orders that some or more of these 7 senators, the alleged miscreants, were not properly elected, were disqualified the date they nominated in 2016, then the court will set in train a process that, in Mr. Joyce's case, for instance, would lead to technically it's called a re-election, okay? Because this is the House of Reps. And you can't really do what Tony Windsor wants to do and just fill the seat with the next highest vote getter in the seat, because that robs the majority, the Conservative majority in that seat, of their real party choice. But in the case of proportional representation and the Senate, the majority of the 7 before the High Court, the court has said in the past, well, you just pretend they were dead, because they shouldn't have been on the ballot paper, and you can recount the votes, press of a button. The Electoral Commission can recount the Senate ticket votes, and almost invariably what will happen is that the next person on the party list from that state in 2016 will get a windfall. That's why we can predict that Senator Ludlam will be replaced by the young gentleman who was number 2 on the West Australian ticket of the Greens, for instance. Right, that's the process for those consequences. But there are more consequences, and if you've read the Financial Review today or yesterday, lo and behold, the Financial Review reports that Senator Roberts is very, very likely to re-enter the Senate if he's found disqualified via this workaround, which I call the revolving door option. And remember, Senator Roberts is the one of the 7 closest to, you could say, well, there was some significant negligence on his part in this whole saga. Now, what Senator Roberts can do, and what the Financial Review says the One Nation Party in Queensland wants to do, is, well, he's already renounced his dual citizenship. He did that late last year. So he's not currently disqualified to sit in Parliament, but the High Court might rule that he was disqualified to be elected and backdate his election. All right, when that happens, the number 3, Senator Roberts, we had 2 One Nation senators in Queensland, the number 3 is a gentleman who certainly probably never expected the windfall to be elected. I mean, a lot of One Nation votes in Queensland, but not that many. And he is facing allegations that might lead to bankruptcy in any event. But if he doesn't want to be a senator, if the party leans on him, then all he has to do is the day after the Electoral Commission declares him to be the one selected on the basis of the High Court's orders, he can just resign. Senator Roberts can be renominated by the Queensland Parliament. The only thing to stop that would be if we have an election in Queensland, which is brewing, which could hold things up for both Senator Waters and Senator Roberts. This is complex. This is all angels dancing on the head of pins. Which is great for me, not so great for the, I think, public faith in democratic process. But in any event, what about the House, where there will have to be a re-election? Isn't that the democratic way to do it? Well, we know from past experience in the cases of Sykes and Cleary and Jackie Kelly, who was disqualified. Jackie Kelly in 1996 was one of John Howard's alleged wunderbabes, wunderkins. She won the seat of Lindsay in Western Sydney, the heart of Australian politics. She was disqualified, and the Labor Party took an electoral petition because they knew about it. She was disqualified because she'd been an Air Force reservist. Now, you don't in politics go up and diss the military, do you? But in any event, why was she disqualified when the relevant section of the Constitution says that it isn't a disqualification, it isn't an office of profit if you are a Defence Force reservist? Well, but the Constitution was written in 1900, there was no Air Force. They only included naval and army reservists. So on this odd, prehistoric almost, curiosity, the Labor Party petitioned. Jackie Kelly was ousted by the court. People of Penrith were sent to a re-election a few months after the original election. She got a big swing to her. It's careful what you wish for. The punters who re-elected Phil Cleary nearby, after he was found to be disqualified because he was a Victorian school teacher, supply teacher on leave without pay, office of profit under the Crown. High Court said yes, and said you have to be properly nominated, you have to be properly qualified on the day you nominate, even though, of course, once he was elected, he said to the Victorian Department of Education, I won't be a supply teacher on leave without pay anymore. The High Court said, in its infinite wisdom, no, you have to be qualified on the day of the nomination, not on the day you're declared elected. All right, High Court's not necessarily practical always. Mr. Cleary stood again and got a swing to him. So we're getting a picture that the punters, if I can use that awful term, can see these things as technicalities. Okay, so what will happen if the Deputy Prime Minister, pictured here, not with Incitatus, the Roman steed, but with I think it's an alpaca, could be black llama. Now imagine the Deputy Prime Minister of the country is unseated due to his father's New Zealand birthright being generously bestowed on New Zealand, which is a welcoming country, unbeknownst to him. even though he renounced this within days of his learning of it from lawyers and from the New Zealand government, well, he will stand again in the seat of New England. Tony Windsor says he's going to stand again, which will be an amusing rematch for Australian politics. Because, you know, the government has a one-seat majority. Windsor versus Joyce. Also, if the guy in Port Macquarie that the Labor Party is going after, the post office guy, in the unlikely event that he is sent to a fresh election, Rob Oakeshott, got his name, normally a Conservative name. Rob Oakeshott said he might stand again. Again, Windsor, Oakeshott, they're the ones who kept Gillard as Prime Minister. Okay, hung Parliament, close majority. But what's going to happen? Do you really think the people of New England are going to see Barnaby Joyce as a fifth columnist because of his unknown New Zealand citizenship? No, in normal circumstances they would do what happened in Jackie Kelly's case or what happened in Phil Cleary's case. They'd re-elect the person they wanted to elect with an even more thumping majority. But this isn't quite the same, is it? This will be the weirdest re-election, by-election in history. Every carpetbagger, every media company in town will be there. I pity the poor residents of New England. The eye of the nation will be on them. Money will be flowing in left, right and centre because potentially the fate of theory the government, but also Turnbull's prime ministership will be on the line. This is absurd. Famous Harvard professor Dennis Thompson wrote a piece in the 80s about the temporality of elections. And I write about this a lot in my book on elections as rituals. We have electoral seasons for good reason. Every 3 or 4 years, the carnival cranks up again. We choose, or we kick out our masters. And then the country heals again, there's a honeymoon period. And then slowly we crank up again towards the next rhythmic season. When you upset that season, at least for obscure process reasons, as I think these cases are, you really are upsetting the whole apple cart. I mean, why should the electors of New England have this extra power? Or you might say this unfair burden and weight thrown on them in a few months' time. Especially given Mr. Joyce has renounced his unknown New Zealand citizenship within days of learning about it. Okay, so these things are also going to upset the rhythms of electoral democracy. All right, a bit more on process consequences, then we need to take some questions. You may have heard that the government issues some kind of letter asserting a debt whenever an MP is found to have been not qualified. And I think in the case of Mr. Cullerton, who's not accepted the waiver of that debt and wants to fight on, they've said that he might be responsible for office costs, if not possibly salary of some of his staff. Now, there's a furphy going around that this debt is a bit like a guaranteed court judgment. Now, just because City Hall says you owe them money, does that mean you owe them money? Anyone can issue a notice saying, you owe me money. Normally we're a cynical lot, and we assume when the government says something, we should check. Now, why should someone owe a debt to the Commonwealth? Maybe if they've been fraudulent, okay? Maybe if you've been fraudulent, you hid your disqualification, you knew about it, it was clear. You've caused expense. But we also have a very ancient case, ancient by Australian standards, called Varden and O'Loughlin, one of the oldest election dispute cases, where a senator was challenged, lost their seat, and the High Court said in passing, as it had to do, it doesn't matter, the senator wasn't tainted, none of what they did, their votes in Parliament, are tainted. Okay? The MP's actions were valid. At the time they made their decisions and their actions, they were acting under law. They were the duly declared elected senator or member for that district. And then also in Queensland, in an earlier case where a similar issue was raised, it was held that the MP was entitled to their salary. They were, at the time, properly elected, not fraudulent. They've done their job. Yeah? There's another furphy going round, and I blame some of my colleagues here who have looked into this and taken a black letter view of the law and said, well, there's a possibility that it could be found that ministers' actions are invalid. And that possibility gets turned into, well, the ministers all have to stand down, don't they, because of the risk. Well, if there was a serious legal risk, someone might have started suing by now. And if there's a serious legal risk that what Barnaby Joyce has been doing is invalid as a minister, then that risk must presumably backdate to all the time he was a minister when he was a New Zealand citizenship, which as far as we know would be dating right back to his birth. Okay? But the law can be an ass, but the High Court is not an ass. They have laid the seeds to say the MP's decisions are valid, right? And being a minister is parasitic on being an MP under our system, therefore surely the MP's actions are valid. All right, so I don't believe everything you read. Now, I'm not going to go through all these slides. You have them there if you want them. There are a lot of reform options. There's a lot of arguments for why Section 44 needs to be reconfigured, possibly washed away. The one thing the Commonwealth did do some decades ago was to say, if you're a core public servant, you can take leave without pay. Sorry, you can't take leave without pay, Mr. Cleary, but what you can do is resign from your position and you have an entitlement to be reappointed to a similar position, if they can still have one, after the election, assuming you lose. Okay, that sort of helps the many, many, many hundreds of thousands of people who might have some public employment with the Commonwealth and want to stand. When it comes to the states, I kicked off this talk by saying the states have got rational, flexible constitutions. They don't have anything like Section 44. Gumming up their electoral process. What the states do is just have a very clear list of sensitive officers, judges, integrity commissioners, ombudsmen. Okay? If they nominate, they've forfeited that high office. Why? Because you can't have a sensitive public office and also at the same time be a partisan nominee for election. With all other state public servants, you're automatically put on leave without pay and you automatically are terminated from that position if you're elected. Simple. You don't even have to know the law. It just automatically applies to protect you. Get this. At state level, it doesn't matter if you're dual citizenship for election. The only time it ever matters, in 5 of the 6 states, is if you knowingly took out another citizenship actively whilst you're an elected MP. And I don't think that's ever happened. Why? Because you would know you're doing something that might be a bit odd in the media, but you'd also get advice from the parliamentary clerk. You know, MPs, we're cynical about them, but I think they're entitled to some kind of workplace rights and advice. The other thing we could do is Section 44, have a referendum, try and clean it away. I think a referendum could pass, at least if we maintain current criminal convictions as a barrier for election. I don't think we need to have such a barrier. If people want to elect a prisoner, like Bobby Sands of the IRA, in Northern Ireland, why not let them? But I suspect a referendum arguing that wouldn't pass. But I'm not as negative as some. I think referendums can pass if you have bipartisan support. And if you explain to the population there is a good reason for this. Why should you have a more limited right to vote for whoever you want to vote for just because of this old rule in the Constitution? And then we would just deal with how do we respond to conflicts of interest that are currently existing and arise during the life of an MP? And the states have shown there's a way to do that. But also currently we have a way to do that, and that would be for Parliament to sit on its hands, stop referring these matters to the court, say to the relevant MPs, resolve the issue, renounce, resolve the conflict of interest and duty if it was the case of a Senator Day in involving your family business or something. Get rid of the conflict and we'll move on. Short of a referendum, short of the Parliament being rational and sitting on its hands a bit, well, the High Court's being asked to clarify what reasonable steps are in relation to dual citizens. But I think the Parliament can go back and say to the High Court, we can refer matters to you to get a full, proper legal resolution, but we will take away from you the power to undo elections years after the event. All right, there's some further reading for you, class, if you're really interested. In the wonderful inside story that Peter Brown edits, in first edition of a book that I'm doing a second edition of, but there's also a little Bible by Professor Gerard Carney that if any of you wants to stand for Parliament, that's what I would assign. There's 2 chapters there on qualifications, but it's not easy stuff. There's also a little hypothetical there, but I think I've probably gone a bit over time, and I shall leave time for questions.